on Amendment 2, Lord Eatwell.
My Lords, one issue that became clear during the taking of evidence and the earlier discussions we had on this bill was that most consumers do not realise that the renewal of an insurance contract is in fact a new contract, and that therefore the positioning of questions and the answering of questions, whether at an initial contract, initial proposal, or at a renewal, has equivalent status. And the purpose of my amendment is simply to ensure that consumers are well aware at the time of a renewal that they are entering into a new contract, and that therefore the questions asked at renewal constitute the entire set of questions relevant to the new contract. In the drafting, my Lords, an erroneous word "such" entered the second line, which, if I were allowed a paper amendment, I would withdraw, since, of course, sometimes a request to confirm or amend particulars may not have anything to do with renewal at all. But I wanted to focus simply on the issue of renewal and to incorporate this clause into the bill to ensure that there is clarity about the status of questions and at the stage at which questions are asked. I beg to move.
Line 6, then insert the words printed on the marshal list, with the exception that such in line 2 should be removed.
My Lords, I intervene very briefly in support of my noble friend Lord Eatwell's amendment. It seems to me entirely reasonable that an ordinary consumer buying a consumer insurance product from an insurance company and then renewing that same product in subsequent years or over subsequent periods would assume that the declarations made at the outset are still valid and are still recorded by his or her insurance company. It seems to me that even if that assumption is wrong, that a lot of the responsibility for that mistake lies in the hands of the insurance company, which should keep good records of its clients. Or if it's not prepared to do that, should at least ask as one of the relevant questions, and we provided for insurance companies to take responsibility for asking the right questions, as to whether or not it should make it quite clear in the application form that this is a new contract, and therefore the assured has to begin ab initio to think of what might or might not be relevant and what might or might not be declarable. And I think to void a contract on the grounds of non-declaration, declaration has actually been previously made, maybe several times made, over several years or for several periods by the customer to the insurance company, would be quite unreasonable, quite unfair, and quite contrary to the purposes of this bill.
I must say I have some sympathy with this amendment too. I mean, I don't think I have ever realised that when I renew my insurance, motor car insurance, once a year, I'm entering into a new contract. I just assume it's an extension of what I've done before. And I think that though this may not be relevant in terms of the way the forms are completed, I suspect everybody thinks that these motor car insurance just rolls on from year to year, and it's an existing contract that goes on and on and on. I think that's what one would assume. Household insurance likewise. And I think there are a whole series of policies which we individually undertake, which I think one will be under the apprehension, the misapprehension, in fact, that this was actually just a continuation of an existing contract. So I do think there's a substantive point here which I support.
I just want to add myself to it too. I think it was quite a revelation to me to realise that the insurance contracts weren't actually just rolling on. I never for one moment thought that there would be new contracts, particularly on motor cars. I mean, if you actually add something or subtract something in your household items or pictures or something, that of course you'd be aware of, and you would actually make a statement to that effect to the insurer. But when something like a motor car, I mean, motor car is a motor car, and if you've insured it for 3-4 years, and you keep on insuring it. So I think it's a very good point.
My Lords, I have to say that I was persuaded also by Lord Eatwell, and I would be happy to support this particular amendment.
I do agree persuade me. All I will say at the moment is that I can't see any harm in the amendment which she's proposed. Whether it's strictly necessary may not matter in this case, but at the moment I can't see any harm unless the Noble Lord the Minister can persuade me that there is some harm. I would be supporting the amendment.
My Lords, let me try and persuade the noble and learned. Trying to persuade the noble and learned Lord Lloyd of Berwick of technical matters of a legal sort like this. I'm not sure I'm up to it, but I will try. I think there is an important point here, but the starting, because I also wouldn't have the faintest idea whether a renewal of any of my insurance policies was or was not a new contract, and I think this is an important question. But of course, as a consumer, where would I be if I did know that, or was told that I was entering into a new contract as opposed to a continuation of the old contract? Well, what would flow from that? What am I supposed to do about it? So, yes, there is a technical issue here, but as I will attempt to persuade the committee, this has already been considered by the FSA and by the commissioners and others, and the position is that rather than confusing a consumer by drawing their attention to this point, we need to make sure that they are actually protected through the way that this bill would operate in relation to this very simple question but important question of misrepresentation that we're trying to address. So the point is very much recognised, but let me try and take the committee through the logic of the position, which is to end up saying that we do not believe that this amendment is either necessary or appropriate. The amendment would have two effects. The first of them is that insurers would be required to make consumers aware that renewal constituted a new contract. And then second, that the questions they asked at renewal would have to constitute the set of questions relevant to the new contract. And it may be easiest if I take the second effect of the amendment first, and suggest that it's already achieved by the existing provisions of the bill. And let me set out to the committee how it is already covered. First, in order to have any remedy, the insurer must ask a question. If they fail to do so, or choose not to do so, there can be no misrepresentation by the consumer. It also follows that any questions insurers do ask are the relevant questions for the new contract. Second, the consumer must take reasonable care to answer any questions they're asked. However, a failure to respond, for example, may be considered reasonable if the insurer's questions were unclear or if the consumer did not receive the insurer's letter, a point that was raised in the previous discussions in this committee. In these circumstances, the insurer may not have a remedy. Clause 3 sets out examples of matters which should be taken into account when deciding if the consumer has acted reasonably, and these include, at Clause 3.2b, how clear and how specific the insurer's questions were. And third, even if the consumer has made a misrepresentation, Clause 4.1b of the bill means that the insurer has to show that the misrepresentation caused them to provide the insurance on the terms they did or at all. And the questions an insurer asks at renewal will need to be relevant to a new contract, otherwise an insurer will not have a remedy. So that I would suggest deals with the second effect of this proposed amendment. But if we turn back to these concerns that have been raised in discussion,
What he's essentially saying, I think, is that he agrees in principle with the idea behind this amendment of my noble friend Lord Eatwell, but he thinks that the purpose of this amendment is equally met or equally well met by the general provisions of the bill, the provision that the insurer has to ask the right questions and so forth. I put it to him that that's not the same thing. To say that the remedy is in the general provisions is not anything like as good as providing a specific remedy, because the insurer then has the assuree in the case of a dispute would then have to argue that the general provisions adequately covered his or her case. If we put in a specific provision, then we cover the point much better, much more effectively. And instead of using the subjunctive, which the noble lord has just used, then the assured may have a remedy, the assured then would have a remedy. There's a great difference between those two positions.
My Lords, if I can come on to the second part of the of my response to the discussion, which may help the noble Lord Davis of Stamford. What I wanted to establish first of all is that the government firmly believes, as indeed must the Law Commission have believed, that there was complete protection for consumers at renewal in relation to questions asked, just as there is protection clearly relevant to any contract which was being entered into for the first time. But then I want to come on to the specific concern about consumers may not being in a position where they may not understand the precise legal nature of a renewal and the fact that it is a new contract, because I think we've all agreed, or a number of us have agreed as we've spoken, that we ourselves wouldn't understand that point, haven't considered this point, and I certainly agree that most consumers are unlikely to take that point, or indeed, as I said in the introduction of my remarks, are unlikely to understand the significance of being told that a renewal is a new contract. So what we must make sure we do is protect them in the circumstances of both a totally new contract and of a renewal. And I would suggest that's what the purpose of the bill must be, rather than doing anything that might confuse a consumer unnecessarily to have to consider the nature of the contract they were entering into at any stage. And the critical point here is that the understanding that consumers need to have of their position at renewal is already regulated by the FSA. In this respect, the insurer's obligation under FSA rules is to ask clear questions, as outlined above, which I do believe addresses the concern. The conduct of the insurer, of course, when renewing a contract of insurance is itself subject to regulation by the FSA. There is existing FSA guidance to firms on explaining to the customer about what he must disclose and the consequences of any failure to make such a disclosure. And in addition to that general requirement, the FSA also requires that on renewal of a contract, firms should, and I quote from the FSA rules, take reasonable steps to ensure that a customer is given appropriate information about a policy in good time and in a comprehensible form, so that the customer can make an informed decision about the arrangements proposed. Unquote. The FSA, of course, requires that all communications with customers, including renewal documents, be clear, fair and not misleading. So I do believe, my Lords, that it is unnecessary for this clause to require insurers to make clear that a renewal is a new contract. They are already required to disclose anything that is relevant, and as I've explained, if they fail to ask questions, then there is no obligation on the prospectively insured party to answer them. And just to address the specific question that came up in previous discussions, under the provisions of the bill, a failure to respond to an insurer's request because a letter was lost in the post or delivered to the wrong address is capable of not being a misrepresentation. There may always be circumstances where communications between the insurers and the policyholder break down, and one of the benefits to consumers under this bill is that in such circumstances it is open to the policyholder to argue that failure to confirm or amend particulars because this has occurred may be considered reasonable in all the circumstances. So in conclusion, I would suggest to the committee that requiring that insurers make clear that a renewal is a new contract is unnecessary, both because insurers would not be able to refuse a claim unless duties around disclosure are made clear to the consumer. Existing regulation also addresses some of the concerns expressed by the committee, and the other consequences of this amendment is covered by existing provisions. So, my Lords, I would suggest that this is unnecessary and risks confusing consumers, and I would request that the noble Lord withdraw his amendment.
Whether this particular point was considered at all by the Law Commission, or indeed on the consultation, the further consultation carried out by the government?
My Lords, I am. I have to say that I am not immediately. Immediately aware of whether they did consider it, although I am sure they would have considered everything relevant, and this is highly relevant. In fact, my Lords, I can confirm that they did explicitly consider this point.
Well, my Lords, I'm enormously grateful for the support that I've received around the committee for this particular amendment. And I regret to say I'm rather unconvinced by the Minister's arguments against it. His second argument, if we like, on the issue of confusion and clarification and so on, he quoted the FSA rules, and he said the FSA rules are there and they provide the assurance that everybody will be clear that a renewal of insurance is a new contract. But he himself admitted that he didn't know this. And indeed, virtually everybody around the committee admitted that the existence of the FSA rules had not provided them with this piece of information. They didn't know this at all. And so I'm afraid that the idea that there exists existing protection for the consumer, either in FSA rules or elsewhere, I think that the opinion poll we've taken on this committee is demonstrated to be false.
It may be helpful, and I'm grateful to the noble Lord for giving way, but I think the implication that he reads into my absolute confirmation that neither I or other members of this committee understand or know whether whether renewal constitutes a new contract or not. He has perhaps taken a different conclusion from it than the one I was seeking to draw, which is that we should expect that consumers do not understand, or would not, even if they were told, be able to assess the implications of knowing that fact. And therefore I was trying to suggest that actually the construction of the bill and of the FSA regulations taken together is precisely to protect and make sure that the consumer is held harmless, if you like, in against a background where we cannot expect and should not expect consumers either to know that a renewal is a new contract or what the legal consequences of that knowledge would be.
Well, I'm grateful to the noble Lord because I think he's just defeated the first part of his own argument. In his first argument, referred to the issue of whether there was sufficient protection already in the bill with respect to the questions which, on renewal, a consumer might answer or not answer. The problem, I think, here is that the potential for the catch-all question, have circumstances changed, is very high. And if that particular question were to be asked, and the reasonable consumer, not realizing that this was a new contract, didn't feel that they had to answer all the points they'd made already, might be, if you like, disadvantaged. And the bill gives consumers significantly more rights than they had before. We're all delighted by that, and we're pleased by the construction of the bill. But it does impose responsibilities on consumers with respect to the answers that they give to questions. And I think that we ought to provide a firm foundation on which the consumers can exercise that responsibility. I'm very taken by Lord Lloyd's argument that this would do no harm. And if it would do no harm and clarify the issue of renewal, I believe it would be worthwhile. I'm also persuaded by my noble friend Lord Davis, who referred to the need to argue these positions, this case with respect to the clauses of the bill, rather than have a clear right specified, as I have proposed. So, given the arguments made, which I regret that the Minister did not manage to convince me, and the support which I've heard around the committee, I beg to move.
The question is that Amendment 2 be agreed to, but because of the change in the wording, I think I should theoretically, in any case, read the amendment out. But in fact, I shall just say that, with the exception in line 2 of the removal of the word such, the question is that Amendment 2 be agreed to. As many of that opinion will say content. Not content? My lords, in that case, we have to go to a division. And as not all members are present, we have to allow for a pause of 8 minutes while members who are not present are able to reach this room. However, I do know that 2 members of the committee, I'm looking at my clerk for guidance here, are not here at all. There is only therefore one member of the committee, Baroness Wheeler, who is not here, and whose whereabouts I do not know. Would it be possible to go to a vote? And if it's within one vote, we'd have to go to the 8 minutes, and if it's not, or am I being too revolutionary?
My advice, Lord Chairman, is there is no guidance to do that in the companion, but if both front benches agree to do so, I think it's the will of the committee. Would
the committee agree that that is to proceed?
Is the question whether if there are other amendments which need to be voted on, can't we, in some kind of way, vote on them all together?
No, my lords, we can't do that. All I'm trying to do is to avoid us having to wait 8 minutes. That's all I'm trying to do. So if the committee, if we could go then to the vote, and I explained how that was going to be. The clerk was going to go round the committee and take the.
It may mention as well the options of content, not content, and abstain.
Content, not content, or abstain.
Lord Borry.
Content.
Lord Davies.
Content.
Not here. Lord Eatwell.
Content.
Lord Goodhart. Content. Lord Hodgson. Lord Lloyd. Lord Lloyd.
Content.
Content. Thank you. Baroness O'Coin.
Content.
The result there is therefore contents 7, not contents 1. So whether or not Baroness Wheeler was here wouldn't make any difference to the result. So on that basis, the contents have it. The question is that Clause 2, as amended, stand part of the bill. As many of that opinion will say content. Not content, the contents have it. In Clause 3, Amendment 3.